Hi, everyone, and welcome to today's session. We're really excited to be here. Before you all hopped on, we were actually just talking about how timely this session is today. We've just given the inauguration and a new president coming in with some new laws and rules that he would like to implement. So this discussion could not come at a better time. We're really excited to be here. Thank you, everyone, for joining. So today we're going to be talking about compliance, all things compliance with regards to the EEOC and OFCCP. So we're going to be talking about regulations for AI in hiring. Obviously, that's a huge hot topic right now. Discrimination, background checks, recent news, trends, what is new for 2025. And we're also going to have a Q&A for our panelists today. So as you all are hearing the discussions and maybe even have your own questions, please go ahead and pop those in the chat. We'll be keeping an eye, Justin and myself will keep an eye on that. If it makes sense to pull those questions in at the moment, we will do that. Otherwise, we'll leave those for the end. But would love to be hearing from you all in the chat. Also, feel free to introduce yourself and put your name and possibly your LinkedIn profile if you'd like to connect with other people here. I will go ahead and put all of our panelists' LinkedIn in the chat too, so you can connect with them as well. So on that note, want to do a brief introduction for our panelists. So Justin Schmidt with JobSync, he's going to be doing the moderation and facilitating the conversation. And we have Genil Washington, VP of Global TA at Druva. Also, side note, she's an advisory board member for Talent Collective, so very special place in our heart for Genil. And then we have Leah Daniels, and Leah is the Chief Commercial Officer at JobSync. So thank you so much for our panelists for being here. We're very excited to hear from you and learn from you. Compliance is a topic that I don't know much about and have never worked at large public companies. So I personally am really excited to learn more and be educated today. So again, as everybody is rolling in, please feel free to introduce yourselves, put your questions in the chat. For those of you who don't know, my name is Krista Tan and I am with Talent Collective. I'm one of the co-founders. We are a community for women in the talent acquisition space. We put on a lot of really great webinars and fireside chats just like this for the public. Everyone is welcome. And we also have a membership community for women. And we do a lot of professional development, mentorship, and whatnot for women in recruiting. So on that note, I would like to pass things over to Justin to start off the panel.
Thanks, Krista. My role today is purely just to keep us on track and on time. The amount of expertise between Genil and Leah is quite literally 1,000 times that of mine. I just like to talk and am the marketing guy here. So to get us started, Genil, why don't we start with some definition of terms? EEO, EEOC, OFCCP. If you could just maybe table set a little bit for us, kind of what those are, how they are related or not related, and we could use that as a good jumping off point.
All right. I'll start. I mean, we hear a lot of these acronyms, and sometimes we use them interchangeably. So let me just start with EEO. So EEO stands for Equal Employment Opportunity. It's a set of civil rights protection policies. We also know them as Title VII. And these are policies that prohibit employment discrimination on the basis of race, color, religion, sex, sexual orientation, age, national origin, physical and mental disabilities. So think of EEO as the policies, right? Civil rights, Title VII policies. The OFCCP and the EEOC are governmental agencies, right? So the OFCCP is a part of the Office of Federal Contractors Compliance Program. It's under the U.S. Department of Labor. And what the OFCCP does is they enforce policies that protect government contractors from hiring discrimination. So they really enforce hiring practices, ensuring that there's diversity in hiring. On the flip side, the EEOC, which is the U.S. Equal Employment Opportunity Commission, once you're hired, so I want to just kind of show the correlation between the two and the bifurcation between the two agencies. They ensure that they prohibit discrimination once you're an employee. So they focus on preventing workforce discrimination of all types, and that's hiring, firing, promotions, harassment training, wages, and benefits. So most of you have probably experienced producing an EEO-1 report annually. That is coming from the EEOC.
Awesome, thank you. And Leah, just to set the stage a little bit on some of the common places where either AI, automation, et cetera, are used in the hiring process, specifically maybe some of the pieces of this that are either in the news or in the zeitgeist or top of mind today, that would also be, I think, a helpful starting off point.
So AI, as we all know, has been around for a very long time, but really became accessible when ChatGPT put a UI in front of it and we all got to start playing with it. And within a minute, every tool you've ever thought about in your life is now AI powered. So what does that mean? What does AI powered mean? And what does it mean when you hire? So when you think about that in terms of regulation and what's happening, it's mostly at the state level that we're seeing AI requirements. Many of things are focused on either disclosure of that you're using AI or how you're using AI, and giving people the option to opt out. So those are two big ones for you to think about from an AI perspective. But it gets a little more interesting as you dig deeper. So for those of you who are news junkies like I am, Workday has been under a lawsuit for the last couple of years now. And last spring, the EEOC weighed in on it and said this is definitely plausible that your technology can contribute to discriminatory behaviors. So classically, the technologies have all been not held accountable. It's like, oh, they can do no harm. It's just technology. It's you as a business are responsible for the outcomes of your practices and the technologies that you select. And in the Mobley case, they're essentially saying, actually, no, it's possible for the technology itself to be discriminatory, and you, as a technology vendor, you need to be responsible for that. California has also recently sent out legislation with similar language and similar perspective. What does that mean? And what I thought about as I was sort of digging into this case over the summer, the candidate, the person who was saying I'm being discriminated against, said the following words: I fill out an application. You asked me a bunch of questions. You asked me my gender. You asked me if I'm disabled. Right? You're asking, you're getting my resume, and on it has my graduation date. So now you know my age. You are actually collecting a lot of information that you can use against me as much as you could use it in an affirmative action type manner. And Workday said, no, we don't do that. It's not us. Our AI doesn't do that. But prove it. How do you prove it? And that's where this gets really difficult, is how do the AIs, which are somewhat black boxes, are able to prove whether or not they're acting in discriminatory ways. Now, part of, I think, any organization's general philosophy should be to watch those outcomes regardless, right? You may have to chase back to see what's happening, but those outcomes are definitely one of the things. Unfortunately, a laggard, they're going to tell you late that you've got a problem, but at least you have something to look at and say, all right, we need to work on these things. But as AI becomes more pervasive and there's more black boxes, there's a secondary problem. So the choice to opt out is a really interesting one. So you choose to opt out. And Workday purchased a company called HiredScore. I don't know if anyone's using HiredScore today. HiredScore uses an AI to assign a score based on your qualifications and the job expectations and some other things. And you can choose to opt out. Genil, do you know what happens when you opt out on HiredScore?
I think the challenge with a lot of these tools where it's doing the scoring, and a lot of them, the intention is to provide the recruiters with the best match. So the candidates that's the best match. So what happens is that the recruiters are going to focus on the folks that appear in their on their dashboard that are the best match. And everyone else that has opted out or has not, the AI functionality is not picking up people that are not considered a best match are going to go to the bottom and may never be considered in the applicant pool. And that's the challenge, you know, with some of the AI functionality that's out there.
Yeah, so candidates who are choosing to opt out are damned if you do, damned if you don't. Sorry, can I say that, Krista? Am I allowed? Okay. Position, right? And they don't know that opting out means that they're gonna go to the bottom of the pack. They know they've opted out. And if you're a recruiter right now, in a lot of industries, we're getting inundated with resumes and applications, right? So 300 applications overnight, and you didn't opt into the AI, I may never look at you. I never consider you as an option. So I think it's an interesting space that we're in right now with how to allow candidates the autonomy to not be analyzed by an AI, but also give them a viable chance of getting the position and the opportunity. So, Justin, I know that's a lot to unpack really quickly, but I think there's a lot happening in AI, and it's happening faster and faster. So we didn't talk about later, right? So the AI's in interviewing. Right, and so we're starting to see an AI live in video interviewing, and it's doing sentiment analysis and trying to read the expressions of your candidate. And what does that mean? What is it using as its basis?
Right.
Right. What data is it using?
Justin, before we move on, I just want to go back just a
Please.
little bit, just to kind of highlight some of the things with the Mobley versus Workday case. And why Workday is really, it's going to be interesting in the outcome of this case. Workday is actually, you know, their ATS is actually interesting because it's a part of a core HR system, right? So when you think about the information that a pure ATS, like, you know, I don't want to name any just to, you know, market those and bias anyone on different ATS tools, but most of them are standalone, or they may have some CRM functionality, but they're not a core HR system where they capture more personal information. They have family information. So there's just a lot of information that is a part of Workday. And as an applicant, you know, under OFCCP, you have the opportunity to voluntarily disclose your demographic information at the applicant level versus when you're hired, it's really a requirement to provide that information. So it's going to be interesting to see, you know, the outcome of the Workday case because of the breadth and depth of information that they have in their system.
Oh, to your point, and where it's stored and how it's utilized, right? So I mentioned HiredScore, and I do know that HiredScore does not tap into the demographic information in Workday for its algorithm. With that said, it doesn't do that as long as you are using Workday the way it was meant to be used. So as a company, you can hack Workday. You can use the questionnaires for your demographic collection, which you may want to do because you want to make it easier for yourself later on, so you don't have to ask the questions again. Well, now that data is available to the AI. And so making sure you understand, one, where your data is being stored and how your other tools and data pieces will be connected to it, which sort of leads me to another thing, which is at some point we have to realize that as recruiting teams and HR teams, we need data scientists on our own team to help us understand our own data because it's getting wildly complex. Like I don't think it's a realistic expectation for any person in the recruiting team to know how databases are structured and working and how your tools are touching things. So it's a whole other problem that we're going to face, I think, in the upcoming years, potentially as these things get more prolific and more data is collected and we have more information that's accessible.
Yeah. Speaking about data collection and how that's changing, hold aside any executive orders that were recently signed and what happened on Monday, but just thinking about how here in the United States we have 50 states for now that are united together as a in a common country, but they all have different laws, right? So, Genil, one thing we discussed a little bit when we were doing the prep for this too, is how these regulations, and you can use this as a jumping off point to get beyond simply the AI piece if you want, but different states have different laws regarding the use of these things and the data collected. The EU has an entirely different stance than the United States does. There's a huge patchwork of rules and regulations that global hirers have to sort of deal with. I know in your work, this is something that's top of mind for you. So maybe if you could just help us understand a little bit about that environment and maybe point to one or two things that folks can do to best prepare themselves and manage this as they scale.
Yeah, I think, it's difficult, right? When you are a national company, right? So you're working across the United States, because each state is so different, right? You have the federal laws, and then you have state laws. And you have states that are more employee friendly, and then you have some that are more employer friendly, right? So, you hear things like at-will employment and right-to-work states and those types of things. I think one of the things that's interesting as of recent is all of the pay transparency laws and how we have to manage, pay transparency, when you are operating across multiple states. And with all the, remote work, hybrid work, we still have some remote work. And I think remote work made it more challenging because people could work anywhere. Now people are now returning back to the office, so you have more hybrid work. But I think, the biggest challenge as an organization is how do you operationalize, all of these state, requirements and practices, so that, you are not getting dinged. I'll just, I'm not going to use any fancy words. I'll just leave it as such, right? And I can tell you from my experience what we typically, and I'm just going to use something as simple as pay transparency. What we've typically done in the organizations I've been in since pay transparency is rolled out is you typically try to take the strictest law, right? So you typically find like California and New York, they're pretty much, two states that have really strict laws. Denver is kind of a close second behind those two states. And you try to, operationalize the requirements for, the strictest laws and, operate it across, making sure you're not missing anything, because states are not going to scream at you if you go over and beyond what's expected, as long as it's not, causing any adverse impact to anyone. And so that's typically what you have to do. Same thing, with hiring. Hiring, when you think about OFCCP, it's pretty consistent in regards to, the definition of an internet rule and the things that, you have to look at from the hiring, interview and selection process. So that's pretty, similar, or it's consistent. I think where it also gets tricky is like you have states with ban the box laws, where, you have to make sure that when you start looking at candidates that have arrest records, how do you treat them, right? And so you've seen, I think this happened, I don't want to age myself because I'm getting ready to age myself. I've been in TA longer than I want to admit on this call. But there was a time when, candidates, when they filled out an application, they had to indicate if they've ever been arrested, right? If they have any felony convictions and so forth. And with the ban the box laws, you no longer do that. And so most states followed suit. Companies, took that question off of their application. They just kind of took the strictest law because, San Francisco is one that has like even additional requirements on top of the ban the box laws in terms of the San Francisco Fair Chance Ordinance. And so, so I would just encourage anyone on this call, any TA leader, manager, what have you, that work with your legal team. I've always taken the approach of taking the most strictest law and trying to operationalize the states or parts of the U.S. That have the strictest laws. And it even becomes even more challenging when you're a global company. So I'm in a global company. So you have the EU and you have GDPR rules. And that's where you have to also start to look at your technology, your ATSs, to see, can you support, the requirements in different parts of the world, that you can't just, approach it from this pretty peanut butter approach where I'm just going to take the strictest law, apply it across all the states, and that's that. So when you think about it from a global perspective, now you have to have an ATS that can operationalize, okay, GDPR, I got to make sure that if candidates want their information anonymized, then I get a notification, I anonymize their records, etc. Right? So again, this is just, from pearls of wisdom and doing things wrong at times and learning, from your mistakes. You really want to have that relationship with your legal team. If you have an HR compliance, making sure that you're in compliance with the requirements, the regulatory requirements of each of the different states that you are doing business in, as well as countries if you're a global company, and making sure your ATS or whatever technology you use, CRM functionality, whatever, complies with the requirements in that part of the world.
Yeah.
I think it's important to make sure you, as an organization, understand the difference between the rules that govern you as the employer and your information. So, for example, in Colorado, it was pay transparency. If you are hiring in Colorado, then you need to have pay transparency on your job. Where other laws have nothing to do with where you are at, but has everything to do with where the candidate is at. So the New York law 144 is about candidates that live in New York City proper, and the EU GDPR rules are about the candidates that are citizens, not even physically located, but citizens of the European Union, right? So the complexity can be extraordinarily high when you start layering in the difference between where the data of the people inside your systems might be physically located or where they are a citizen of, versus the rules that operate for what behaviors you can do and not do based on your own business and where your business is located or where the hiring is located. So for sure, it gets complicated. One of the things that I often kind of revert back to, and you're going to date yourself, I'm going to date myself. In 2003, the US federal government rolled out Can Spam, right? 2003, 2001, one of the two. I think it was 2003. Can Spam. And the reason we did that was because there were a variety of varying state laws on managing spam in your email. And they were conflicting. And they had to do with where the person was located. Well, when you're emailing someone, you don't know where they're located. It became very difficult to comply. And so once we started reaching a point where there was too many conflicting laws, the federal government sort of rolled in and actually created one of the more benign roll-ups that you could have asked for in terms of Can Spam. The US is one of the sort of lowest to comply with laws on that front. And it is a function of sort of time, right? You just have time sort of drives you into that place. And I think we'll see that with pay transparency, for example, where time is going to drive us to unify, if Indeed doesn't make us do it first. Because there is just overall a reality that being transparent with your pay does have a couple of benefits. One, candidates are actually happier. They will apply to your job because they know. And two, you're creating a more fair workplace by having clearly defined compensation for the work that you're going to provide. So I think that there is sort of this side benefit that is actually secondary to the fact that just unification makes everybody's life easier and gets rid of confliction in the market.
Yeah, excellent. So the next topic we had in our outline is the one I think kind of most real time and quite frankly potentially raw of everything we had lined up to discuss today, and that's looking at specifically some of the regulations and understanding the milieu that hirers have to operate in around diversity, discrimination and some of the other practices that we have worked towards building to create a sort of equitable economy for everybody. This part of the discussion, I think, is one where I'm really interested to see questions from folks. Leah and Genil, I know you guys both have a ton to say about this, so I want to kind of just kick us off with, we talked about in our prep call the Harvard decision. That very decision was mentioned in the executive order that came out yesterday, and there's some very, very interesting ramifications from both that decision, but then also kind of what we've learned in the last 24 hours. Genil, if you want to maybe start us off here on like what the Harvard decision is and kind of like the direction it sets, and some of the implications there for hiring teams. Because it was a decision about college admissions, but that has effects, beyond just college admissions.
Yeah. So when you think about the Harvard affirmative action lawsuit in 2023, the Supreme Court ruling barred colleges from using race as a factor, right, in admission. So Harvard, made these changes to its admission process to comply with the law, but they were still trying to maintain some diversity, right? I'll leave my thoughts to the side for a minute, right? So what was interesting about the Harvard case, and I think it's going to continually come up, is that, so the people in admissions were no longer to access information about an applicant's race on their application. But what's interesting about that is that students that were applying to Harvard for admissions could still discuss race in their essays, right? So they could still talk about, like things that led them to come to, to get where they are. They could talk about life experiences that shaped them and made them the person they are. And they could include that in their essays when they were seeking admission to Harvard. What's interesting, right, is there's a lot of interesting things about the Harvard case, and I think there's going to be a lot more to come. But, what's interesting is after that ruling, Harvard then tried to step up some of its recruitment efforts by really attempting to provide more financial aid to attract more diverse students, right? So it's like, I don't want to use race as part of admissions, but I do want to focus on trying to figure out how can I recruit a more diverse student population, and I'm going to attempt to do that by financial aid. So I'll leave my thoughts on that aside too. Okay. So what's interesting is that there has been a decline in some of so for some underrepresented minority groups, right? So, there has been a slight decline. There's been about a 4% decline for Black students. And I think it's about the same or similar for Hispanic students, right? And you're seeing some of this also play out in other colleges, like I think it was Yale, where you started to see Asian students that were, I think, impacted more so than any other minority group. So, it's going to be interesting, because the one thing about the Harvard case is that they still apply, they still look at if you have relatives or you have parents or your descendants of alumni from Harvard, which, you're not wanting to use anything that gives anybody an advantage. But when you look at it from potentially a socioeconomic standpoint, you are still giving an advantage, right? So I think what's going to be interesting about the Harvard case and its long-term effects, it's going to be interesting to see how down the road it really has an impact on, the diversity of the makeup at that university. What's also interesting, and I don't want to be long-winded because I know Leah has we had a really, healthy, really good dialogue about this, is that some of the other schools are starting to pick up some of the students that potentially might have gone to Harvard, but they're starting to see an uptick in their diversity student population. So it's going to be interesting. It's going to be interesting to see the outcome and the ramification of this ruling. Leah, I want you to share your thoughts because I know you have a lot of opinions about this case, which are really interesting. And so I think I'd love to turn it over to you about your thoughts here.
I think the first thing that's super interesting about this is Harvard is not a public education, right? They are not the University of Filling the State. They are a private institution, which does get federal funding. So it's an interesting statement. But they are a private institution, and they, from what I can tell, very much disagree with this ruling that came down and have done a lot to sort of combat it, to try to organically keep some of the numbers that they had from a diversity standpoint. So they did add this question around the lived experience, in which they're trying to encourage students to provide more information, allowing them to create diversity of thought within the university's walls. You mentioned that the enrollment numbers, especially for Black students, had gone down from 18% to 14%. That over time, though, will have a major impact in terms of what the alumni diversity looks like in the Harvard, the Harvard alumni group. And the reality of Harvard is that if you get into Harvard and then you go try to get a job later on, there's a good chance you're going to get an interview. There's a good chance, right? There's a perception that comes with a school like Harvard. And so it is an important thing to note that we are going to see less and less students of color at Harvard, and what that will mean over time to our, to our hiring population and how we look at people and hire them. The thing that I think is important, though, about Harvard is it sets a almost like a stepping stone for what has happened in the last 3 days in terms of executive orders. And so now we're starting to see the administration try to remove any sort of activity around DE&I efforts. So everything we just talked about around the OFCCP and being, collecting data and being conscious of what you're doing as a business and the outcomes are all on the table right now. So what happens in the next month, year, 3 years, 4 years, but more importantly, what happens in the next 6 years and 10 years? So for me, what's concerning about this Harvard decision is while I don't love what happened for Harvard and the other universities, I'm really concerned about the long-term impact and how it's being sort of wielded as a weapon to justify what we're doing now. So for those of you guys who have not stared at the news calendars and tickers for the last couple of days, a number of executive orders have come out. The first, I would say you could argue, is dismantling the OFCCP. They've removed, at this point, they have furloughed, for lack of a better word, all of employees that are in the federal government who hold a DE&I title, or whose responsibility is overseeing DE&I within the federal government. We are seeing challenges to flexibility around the word gender. So we have moved back to the word sex. We are now into female and male. There is no third option any longer when it comes to passports and other types of governmental documentation. So there is a very rapid approach happening right now to dismantle this. And what's concerning is the language that they're using, which is we are removing illegal discrimination. So if you're following this, the legal discrimination terminology came out just after the Harvard case around describing what affirmative action was trying to do. So they're now calling affirmative action illegal discrimination. And that's what we're seeing in the language in these executive orders. So for me, I look at all this and go, wow, a lot of these are private organizations. You actually have your own rules and credo and morals that you want to operate under. And you have a federal government saying you can't engage in some of these behaviors. In fact, one of the executive orders is actually charging the government with investigating companies who are continuing to pursue affirmative action programs, which I don't even know what to say about that. So we are in for a very interesting few years. And then there comes another question, which is in 4 years when we have another administration, what if it all gets reverted back? What do we do then, right? Anybody got a crystal ball?
I do not. I have plenty of fidget toys and other things behind my room divider there, but no crystal ball. But
yeah.
Genil, you're getting ready to. Sorry.
Yeah, Justin. I just want to say what's interesting though is when you speak about crystal ball and you think about what the federal government is doing in terms of putting a lot of the employees or federal workers that have a DE&I title on administrative leave with the with the termination date, right? Let's just be a real here. We've also started seeing some of these companies say that they're going to start to pull back some of their DE&I efforts. So you've seen companies like Walmart and a bunch of other companies that have said that they were not going to continue to support DE&I efforts. What's interesting though is that those companies some of them have gotten some backlash, and so they've pivoted, right? So what they're doing is they're rebranding their DE&I, so they're not totally taking it away. They're rebranding it, so you'll start to see more of inclusion and belonging and things like that. Because the reality is we live in a world where we are very diverse, and that makes us a wonderful world because we learn from each other's similarities as well as differences, right? And we'll find that we have more similarities than differences, right? And companies have seen that when you look at it from their bottom line, that diverse teams are more productive, right? So there's a financial benefit to having diverse teams.
Yeah.
And I don't want to kind of cover a whole bunch of topics, but I think people really need to understand what affirmative action is, right? And affirmative action is not saying I have to take someone from an underrepresented group that's not qualified and hire them. It's not saying that I have to take someone that did not get the grades in colleges and admit them, right? Because you still gotta get the grades to stay in the school. You still got to be able to perform. Still got to be able to perform on a job, right? What it is saying is that, look at your census data, and in the communities that you do business or you're pulling your candidate pool from, look at your employee population and see if they resemble, right? See if they mirror the communities that you serve and you do business in. And if you have an underutilization of someone in a protected group, be it gender, be it women, be it Black, Hispanic, then when you have an opportunity to hire, then consider the underrepresented group that you don't have within your organization in your hiring. So I think that needs to be something that people understand. It's not that DE&I represents you did not earn it or you do not qualify. What it does represent is, hey, look, we're all human. We have our professional groups. We typically tend to hire people that we're comfortable with and look like us or from our professional, network. And so why don't you consider someone that may not be in your professional network that's qualified and can help, with productivity and performance on your team, right? So that's what affirmative action really is. And I think it just has so many negative, connotations surrounding affirmative action that it's easy to be misunderstood and misperceptions that are out there.
I think there's two things. McKinsey put out an article, this was a couple of years ago, that really went deep into organizations and understanding performance, like the bottom line, the thing that companies all care about the most. Who makes the most money, right? Who's the most profitable? And the reality of the data is that diverse teams perform better overwhelmingly. Mm-hmm. We know this. I think where we get, as a people get stuck is that while we may know this, we don't always act in that way in a micro setting, right? When you're making this one hire. And a lot of these affirmative action programs give people the rails and the rules in which to make a better choice, to make a better decision for the business, and not, I'm just going to hire them on my gut because I know, I can feel it that we're going to be great. Like you can get rid of that nonsense and you can start to hire with a much more pragmatic way that has an approach that follows a consistent set of standards. And I think for a lot of organizations, these programs have done that in order to help the organization overall. And so it's curious to me what will happen when we take the guardrails off, or if we take the guardrails off, right? Do we allow the micro decisions to influence where we hire to the detriment of the business? Mm-hmm. Not any given hire, but it's the aggregate of, right? And I think that that's where the next decisions that these companies are going to make around how they step forward will have a lot to do with what their long-term outcomes are as a business. Do they continue to keep these rules in place, whether or not they're legally bound to or not? Or how do they operationalize them, which is a different question, right? So if I've sort of played out the what ifs, we just say, you know what, you can't collect diversity information anymore. There's no more of that. You can't do it as part of your application process. How do you, as a business now, ensure you're still being fair, you're still considering all your alternatives, right? So I think it's a good thing for companies to start thinking about now how you're going to operationalize going forward under some, assumptions that maybe aren't fully baked, but seem to be headed in that direction, that we may not actually be held accountable to the EEO one reports anymore, that we may not have to do our annual OFCCP reporting, which will provide the data on how we are collecting and accessing candidate pools. So we don't have to do that anymore. How do we then operationalize the business? I don't know. Those are my questions for just for whoever would like to jump in.
Yeah. So to kind of wrap up here, one of the things we wanted to make sure we discussed was how to operationalize. And if I'm misspeaking, Leah or Genil, either one of you want to kick me under the table here, please do. But at the end of the day, there is a impetus for all of us to try to make sure we are representing the population that we are hiring from and serving is represented inside the business that we are building. Like McKinsey probably spent $7 bazillion building that report, but usually when they do these things, they come out on the other end more or less accurate. So we have the data to prove it. In regards to AI regulations and anything related to hiring, it's generally a good idea to kind of look in your market, follow the strictest rules. Every business is different, talk to your legal team, et cetera, but that's generally a pretty good way to approach it. And then from a regulatory perspective, depending on what you have or can't, what you will, won't, can't, or should add to your application, your questionnaire, building your applications, building your workflows such that you're accurately capturing this data, which, by the way, doesn't have a huge impact, if any at all, on application completion rates. It's very clear. But having that data in 4 years, if this all gets reverted back to where it was 2 weeks ago, then you've got that data to survive any audits that may come in the future. Is there any other piece of operational wisdom that we could leave the panel with here on how to think about these issues and be successful going forward? Janelle, do you want to take the first
Yeah,
stab at that?
I'm going to start off with, let's just think about what the OFCCP looks for, right? When they conduct an audit. I'm going to work backwards, right? So what the OFCCP typically looks for is they look at applicant data, right? So they want to make sure that, the way you're treating applicants it's consistency, right? So you want to make sure that your interview process, whenever, you have a specific job profile, that there's consistency in how you're moving applicants through the process, right? That you are reviewing candidates the same way, you're applying the same criteria. And, if you're not familiar with the OFCCP, I would encourage you to go on their website. It's really important as a recruiter, you understand the definition of an internet applicant rule. And you're using that criteria when you are considering candidates to move forward to your hiring managers, right? So they look at your applicant data and how you're moving candidates through. They also look at dispositions, right? So the way you disposition your candidates, right? You don't want to just do a blanket disposition, and you want to make sure your disposition reasons match the stage in which they are in the process, right? So it's really important to have really clean and compliant disposition reasons. You have a consistent process of moving candidates through. They are being reviewed, or the selection criteria is consistent across the board, right, for a specific job profile. They're going to look at hiring and compensation. They're going to make sure that OFCCP is looking at, is there any disparate impact in how you're applying your salaries. That's really the pay transparency is born out of inequalities in how compensation is applied when people are hired, right? So you're going to want to make sure that based on someone's qualifications, you're consistent there. They also look at internal promotions, right? I know in smaller organizations, sometimes you just want to get someone, you want to get them moved through. You don't necessarily need a job posting, but there's pros and cons to that. And you got to really decide, how much risk your organization wants to take when you're treating your promotions and transfers within, right? And then, your affirmative action plan. Your affirmative action plan, all government contractors are supposed to have an affirmative action plan. And actually what the OFCCP did in the last, I think, 1 or 2 years is they want you to show proof that you have an affirmative action plan. Before you didn't have to certify it. Now you have to certify it. So it'll be interesting to see what happens with this incoming administration. And so with your affirmative action plan, they want to see that you've made good faith outreach and efforts to make progress towards your diverse employee population. And then they're going to also test to make sure that your job postings are compliant with all the pay transparency laws. You're going to have to show proof of that. So what I would encourage, just in a nutshell, is these things are things that should not be just tied to OFCCP. And if the government decides to change their stance on DE&I practices, if they defund the OFCCP and Equal Opportunity Commission, this should not change how you treat applicants coming through the process. You should still have a consistent process, because it's only beneficial to the organization on how you're comparing candidates as they're moving through the process. So I would just say, be consistent, have consistent hiring practices and selection and assessment. And then, as the pendulum changes, you're not caught, off guard with your applicant data.
You just said something really interesting. So pay transparency laws are around displaying the pay transparency. And one of the tricks that I have seen a handful of companies implement, which I think is extraordinarily good practice, is as you're putting your pay transparency and you're looking at your job requirements, you should be looking at, if you have two numbers, a top and a bottom, you should be looking at those requirements and saying, what does it take to get to the low number? What does it take to get to the high number? And maybe even what does it take to get to that mid number? And have that determined before that job goes out, not when you're looking at the candidate you really like in front of you. So if you can say these are the requirements just for you to even be considered, that's the low number. If you have 5 of the following 8 optionals, now you're in the middle number. And if you've got it all 8, now you're at the high number. And you have that clarity, that makes a lot of these conversations in the documentation much easier. The second thing is, with pay transparency, we talk a lot about publishing, but there's a secondary piece, which is when you ask candidates, what are you making? Well, there are some states you cannot do that. So are we asking the right question, right? If we're going to ask that question at all, or are we eliminating that question entirely and focusing only on, this is what our compensation range is, and this is how you get to the different levels within that range. So those are some best practices that I've seen on that front. The other thing that I thought is just super interesting is for all of the goodwill of, I think the EEO putting together a really nice long list of websites in which you should go and try to recruit off of to encourage diversity. The reality of the market is that everyone we're hiring are human beings, and they go to the same 3 websites. So that's unfortunately, this is not an advertisement for any of them, but there is a reality that the majority of your candidates, diverse or not, are going to come from some of the same places. So keeping that in mind as we are hiring, it's not always just because we put a job out on a diversity first website that we are going to find the candidates we're looking for. They may just come through our normal means, including our corporate website, right, where we've done a lot of good work and brand work and so forth. So all good things to think about on best practices.
Awesome. That does it for our outline of what we have discussed. We have a few minutes left if there's any questions. I don't see any in the chat that we didn't answer in the chat directly. So if we don't have any other questions, I think that wraps. Krista, any other housekeeping items we need to attend to?
Thank you. Yeah, this has been great. Thank you so much to our panelists, Leah and Genil, and Justin for moderating here. Really, really amazing discussion here today. A couple just last things. So we will send out the recording. Sounds like Justin and JobSync have some resources that we'll also send out with the recording. Also, if you're interested in more events from Talent Collective, we have a few really exciting things coming up. One, if you do business development and lead gen as part of your role, we have a discussion next week on that. And we're also doing some interesting workshops on leadership and wellness. So not just TA topics. So join us for all of that. We also have just announced that we're leading a new conference, so a new talent acquisition conference in Scottsdale in June. That is also going to be a blend of wellness and TA. So we're doing a new take on the whole conference route and trying to do things differently and innovate for TA. So follow us, and hopefully you all can connect with our speakers today as well. So thank you all again for joining us. And tune in for our next one.
So thank you guys. Thank you everyone for joining.
Thank you, everyone.